have with us via Skype Gary Mayerson from Mayerson and Associates. He's a civil rights attorney. They specialize in representing individuals with autism and related disorders, and they have represented over 1,000 individuals in more than 30 states, including Alaska. And before we went to break, I mentioned that there's some news coming out from the Supreme Court this morning. Enlighten us, Gary. Tell us what's going on that's really important.
Yeah, this is extremely important. The Supreme Court sometimes doesn't take even one autism or IDEA type case in the year. It's not unusual. This year they've taken 2 cases, and just this morning they took one of the most important cases that have ever to hit the Supreme Court. The name of the case is called Endrew F, E-N-D-R-E-W-F. And what it's about is the standard of care that school districts have to employ in order to satisfy the statute. The statute says, as many parents know, that you have to be receiving what's called a FAPE, free and appropriate public education. Unfortunately, the IDEA statute never defined what FAPE meant or what appropriate meant. So the courts around the country have been struggling to define that standard. Some school districts and some circuits have held that the standard just has to be what they call something more than de minimis. And other circuits have said that the services that are being provided to the student must be meaningful, okay? So this case is going to reconcile the standard as to whether or not it's this just more than de minimis or whether it has to be meaningful. And that will have a tremendous impact on cases heard around the country, for sure.
Absolutely. I mean, this is something we talk about on the show all the time for parents. We take on the subject of IEPs and about them going in, and that, we in the beginning, a parent thinks the most important part of FAPE, the free appropriate public education, is the free part. But what you learn is that the appropriate is where all the argument is going to be, because what an autism parent thinks is appropriate versus what the school district thinks is appropriate is always where the battleground is.
Yeah.
So huge things at stake for us. Much could be lost or much could be gained here. And I understand that that you are on the board of Autism Speaks, and that Autism Speaks has a dog in this fight, as we all do. Talk to us a little bit about what Autism Speaks is doing in conjunction with this case, if you're allowed to. You may not be allowed.
I certainly can. Yes, there's 2 briefs. Actually, Autism Speaks has 2 dogs in 2 different fights.
Okay.
They're in the Andrew F. case. One of my colleagues at Autism Speaks wrote a great amicus brief that was submitted, and it was part of the reason why the Supreme Court took this certiorari this morning. And obviously, Autism Speaks' position is that education, because it has to be individualized, that is the core requirement, because it has to be individualized, of course it has to be meaningful. How could it be anything other than meaningful? And in fact, the Justice Department weighed in with its own brief saying just the same thing. So we're hopeful that the Supreme Court will agree with the Justice Department, with Autism Speaks, and with other advocacy organizations to rule that, of course, if it has to be individualized, then that necessarily means that it has to be a meaningful educational benefit, because why else would you provide the services if it was anything less than meaningful?
Absolutely.
The other case, there's one more case. It's not as, it's more procedural in text, but let me see if I can explain that. The other case, which is called the Fry case, also Supreme Court took certiorari. It's going to be heard on October 31st, and I will be in Washington to watch the arguments. We submitted an amicus brief on this one as well. This one has to do with the procedural requirement to exhaust remedies. So there's a legal doctrine that a parent, before they can assert any claims for damages or injunctive relief and so forth, they must first exhaust their administrative remedies. But let's go back to the bullying example. We were talking about bullying in the last segment. If a parent needs to get an injunction, needs to get a preliminary injunction against the bullying, and it's not available in the administrative hearing, it would seem to be a tremendous waste of time, and it would be a prejudice to the parent if they had to first exhaust all their administrative remedies in the administrative proceeding before being allowed to go for that injunction. So this case, the Fry case, which is being heard on October 31st, will help to determine the limits of this exhaustion of remedies doctrine. It sounds very procedural, but these are procedural rights or limitations that will have a tremendous impact on whether a parent can actually seek and obtain relief on a timely basis.
Wonderful. So if I'm hearing this correctly, then the way the law is now, it could take you a substantially longer period of time in order to seek justice and be able to stop what's happening. And in that period of time, our kids could be hurt.
Absolutely, Shannon. In the TK case, the bullying case we discussed in the last segment, the case itself took, between all the appeals and everything, I mean, the parents won. It took 8 years. Parents don't have 8 months, let alone 8 years, to be letting a situation languish while it's not being addressed in a meaningful fashion.
Absolutely. We can't expect for our children to be going through this at the speed of 8 years. That's insane. So on October 31st, the one case will be heard. The one that they took this morning, when do we expect for that to be heard?
Well, that has to be scheduled by the Supreme Court. I'm gonna expect that that's going to be more like in the spring, and then hopefully by that time we will have a new administration, and hopefully the ninth justice will be confirmed, whoever that person may be.
Let's all keep our fingers crossed, shall we?
Yeah.
Because this is important for all of us. This will have huge ramifications for anyone who is planning on having a school-age child in the next 20 to 30 years. So that's everyone. Because if your child is already done, you're going to have grandchildren at some point, or you're going to have cousins or nephews, or you're going to have. It matters. It matters to all of us.